Well, thanks for inviting me. I worked on Condit Dam relicensing from, I don't know, approximately 1990 to 93 for the National Marine Fisheries Service. And then I continued on with afterwards where I worked for the Columbia Basin Fish and Wildlife Authority until I left there in 1996 to go to Alaska for quite a few years. Anyhow, I'm back working for the National Marine Fisheries Service now, doing Endangered Species Act consultations. So this is stuff I did 20 years ago. Another complete lifetime. Anyhow, I'm going to talk a little bit about what occurred before relicensing came up. There was a lot that went on in the early days, actually, and a little bit about Federal Power Act, some very basic stuff. The relicensing phase, I'll go through that in some detail, and the NEPA EIS phase, a little bit about the settlement phase, and then a summary kind of at the end. Anyhow, here's a map of, you've seen this already a bunch of times, but Condit Dam is about 3 miles upstream on the White Salmon River. It's got a penstock and that goes down to a powerhouse. And it's, one side is Scabinia County, the other side is Klickitat County, and it's just, the dam is just slightly in the Columbia Gorge National Scenic Area. So it's kind of a complicated bunch of jurisdictions there. Upstream of the, what was the lake was a wild and scenic river reach, a study area that became wild and scenic area. In 1968, the license was up for renewal, and this is really in the era when I don't think biologists knew what they were doing. They really didn't, because they asked for a minimum flow of at least 15 CFS, and fluctuations no greater than 2.5 feet in any 24-hour period, which is pretty liberal for a power producer to do a lot of cycling and load following, and the river basically went up and down all day. But the license was granted through 1993, through the end of the year 1993. Bureau of Reclamation looked at putting in their own projects upstream, and they had several dams and pump storage facilities and things that they were looking at. And National Marine Fisheries Service, which just became a federal agency in 1970, came out and suggested, let's look at fish passage at Condit Dam. Because the National Marine Fisheries Service, that's their jurisdiction is anadromous fish, and marine mammals. And so here was a place where anadromous fish were blocked since 1913, except for some attempts at fish passage with ladders early on. But anyhow, they suggested the most feasible, most cost-effective method would be removal of the dam, and that was way back in the 70s. And if not dam removal, fish passage facilities. And a fishway lot would also be required at the Bureau of Recs facilities. So anyhow, that was pretty advanced for 1970, early 70s. And they said the most suitable flow would be about 300 CFS below Condit Dam. And compare that to 15 CFS. The Bureau of Rec did a report and they recommended removal of Condit Dam. And NIMS endorsed that proposal. The estimated production of fish was, 2,700 fall Chinook, I can't read the screen down here, 3,200 steelhead and a couple hundred coho. Production of the 1,500 fall Chinook was dependent on breaching the dam and reestablishment of spawning and rearing habitat between the powerhouse and the inlet to the reservoir. That proposal, the Bureau of Rec's proposal never went anywhere for some reason. I don't know why, but it was just probably funding. Maybe Congress didn't go for it. But Klickitat PUD came in and they proposed a whole bunch of dams around the late 70s, 1980. And one of the studies they had to do was look at fish passage at Condit. So fish passage was talked about for quite a while, well before the relicensing came up. And Pacific must coordinate with the PUD. The NIMS, which has engineers, fish passage engineers, probably I'll have to brag a bit, probably the best in the country. All the other parts of the country rely on the Northwest for fish passage expertise. Everything that's about fish passage was basically learned in the Northwest. They're just learning on the East Coast. But they considered a tail race barrier and a trap and haul and vertical traveling screens for the downstream juvenile migrants. Pacific concluded it was technically feasible, but questioned the potential for anadromous fish production above the dam and raised questions about impacts to the resident populations and cost effectiveness and so on and so on. Pacific downplayed the production potential of the upriver areas. So we're up to 1983 here. There, in this period, you had two state agencies in Washington regulating, working on fisheries. Washington Department of Fisheries, which was salmon and mostly downstream, and then you had Washington Department of Game, which was, they did steelhead and wildlife. So you had two state agencies kind of competing in some cases for authority. So you had Washington Department of Fisheries question whether fish passage would be cost effective. And it's, why is a state agency raising those questions? They wouldn't do that now. This is the times. This is what happened then. They believed that salmon production could be achieved, but wished to continue more studies, of course. So they did some turbid mortality studies and so on. 1983, around this time, the Northwest Power Planning Council was up and running, and they had a fish and wildlife program, and they put in it had a measure requiring fish passage at Condit Dam. So looking at this more, part of the regional picture now. NIMS agreed to reanalyze White Salmon River historical fish production and to provide funds to investigate irrigation fish screening. Upstream, there's a lot of orchards and so on. Some of those weren't screened at the time, but because things weren't done, completely, there was unscreened diversions. That was used as a argument for not removing Condit Dam. I mean, everything that could be thrown at you for reasons not to provide fish passage was thought of. Pacific recommended hatchery compensation for only the losses due to their dam. And they considered, due to their dam, they didn't consider production above Husum, which they argued was a migration barrier. Well, you saw the pictures of the fish production already above Husum. There's salmon and steelhead getting up there. Washington Department of Fisheries begins some experimental fish plants upstream. Washington Game develops a steelhead reintroduction plan above Condit. Up to 1986, NIMS considers petitioning FERC for fish passage, but Washington Department of Fisheries and Game didn't support that, so we didn't plow forward. This is still prior to relicensing. This is Game raises concerns about resident anadromous fish conflicts, threatens to negotiate independently with Pacific. And the agencies basically disagree whether fish migrated past River Mile 16. So, there was all these disagreements amongst the agencies. 1986, the lower White Salmon River above the reservoir was designated wild and scenic, and the Columbia Gorge scenic area was enacted in 86. So there's a lot happening during this period. Upper Wild and Scenic River Study in the EIS, they designated resident fisheries as an outstanding, remarkable value. And I never understood that. We weren't involved, but anyhow, agencies in the Yakima Indian Nation request relicensing studies in July 1990. This is when relicensing really started. Studies on in-stream flow, gravel augmentation, ramping rates, water quality, tail race barrier design, and so on. Now I'm going to tell you, you heard this all this morning, but I'll go over it just briefly. The Federal Water Power Act of 1920 is the Federal Power Act. That is what controls the issuance of hydropower licenses, and FERC is the agency that does that. And it passed when the benefits of hydropower were pretty easy to recognize. There was cheap power. Everything else was pretty much dismissed. Recreation, fisheries, tribal concerns, everything else. However, recognizing the potential for changes in policy and technology, Roosevelt vetoed it, and an earlier licensing bill which would have granted perpetual licenses. So you can basically thank Teddy Roosevelt for this one. Relicensing permits a later generation to re-examine the validity of a project under the laws and regulations presently in effect, weighed against public interest and it's currently perceived. Section 18 authority, this is what we as an agency hung our hat on, because NIMS and the U.S. Fish and Wildlife Service have prescriptive authority under the Federal Power Act for fishways, and fishways were both upstream, ladders, and downstream screens and bypass facilities and so on. And FERC cannot reject them. They can appeal and go to court and so on, but it's pretty strong law. There's been a few landmark decisions, the Escondido Mutual Water Company versus FERC, where basically the court told FERC that, you know, these things are in the Federal Power Act, you have to follow them. There's mandatory conditions in the license, even if the commission disagrees with them. Section 4E does not vest Interior with an unconditional veto power over FERC's licensing authority. Licensing proceedings are subject to judicial review in the Court of Appeals under the Administrative Procedure Act. Interior's conditions are reviewable in district court. And around 1986, the Electric Consumer Protection Act, ECPA, came into effect, which put hydropower on par with other considerations such as fish and wildlife and recreation. Lynchburg Hydro Associates, FERC acknowledges that Section 18 Fishway Prescription Authority rests with the Department of Interior and also Commerce, not in the Commission. So these things affirm what the Federal Power Act really says, which really the agencies, I don't think they knew what power they had until the 80s. But about this time, there was more discussion of dam removal. NIMS did a report on various dam removals that have occurred around the country. So around 1990. Anyhow, but there was a 1990. There was a 70% draft fish passage report, and basically dam removal wasn't even an alternative yet. It was just we were looking at fish passage. We had no idea that dam removal would be feasible or would be acceptable, or that we could get that done. We were still fighting for fish passage. Pacific fought this pretty hard. They hired the big gun consultants, Don Chapman, and we've argued back and forth with him over the benefits of fish passage. Anyhow, there was a lot of disagreement amongst whether fish passage was a good or bad thing amongst the agencies. About this time, Washington Game became Washington Wildlife, 87. Then Washington Department of Wildlife reversed its 91 position on steelhead passage. So one minute they, one year they want it, next year they don't. So there's like all this confusion amongst the agencies. And agencies act, a lot of cases, like individuals, because it's individuals you're dealing with. A lot of the stuff with Washington Game was not centralized. It didn't go through Olympia. 91, the Lower White Salmon National Wild and Scenic Area Management Plan came out, and resident fisheries were designated. A whole bunch of other wild and scenic rivers, however, just said fisheries. They didn't say resident fisheries. So this was kind of a big point of contention amongst the enviros and the fishing groups and so on. We fought really hard with Northwest Steelheaders and the Native Fish Society. These are guys that we thought would be on our side, but they were like, you know, they wanted their trout fishery upstream protected, and they didn't want that dam out because they liked fishing in the lake. Around this time, some species were starting to be petitioned for listing under the Endangered Species Act, and 1991, Snake River sockeye were listed. That sort of broke the floodgates on salmon petitions and listings. 91, FERC accepts Pacific's license for filing. That means that FERC basically says you're done studying it, and then they decide, you know, whether or not and how to condition a license. The agencies were not very happy with that, with some of the conditions. Then you got more listings in 92 with the Snake River stocks. A lot of back and forth on the design of fishways and so on. FERC submits to, NIMS submits to FERC a proposed outline for an EIS. So this, FERC always starts with an environmental assessment, and then if it gets controversial, they will go to the EIS level, which includes public hearings and so on, and a lot lengthier process. And by this time, Condit was getting controversial. And so we submitted an outline for the EIS, and they included dam removal as an alternative. About this time, all the agencies and American Rivers and the Yakima Indian Nation, CRITFIC, Columbia River Intertribal Fish Commission, everybody intervenes. Washington Department of Fish and Wildlife, they merged, recommended that FERC require fish passage. The Columbia River Fish Management Plan Production Advisory Committee endorses natural production. These are the guys that manage the fisheries on the Columbia River. That's interstate, both states. A big important event was the Clean Water Act 401 certification. The agencies recommended much higher flows than Pacific was willing to go with. Then it goes into the EIS phase, and scoping document 1 comes out, and then you comment on that, and the scoping document 2 comes out later. Northwest Power Planning Council expresses support. So you gotta, when you do these things, you gotta round up a lot of support, or you basically, you need as many allies as you can. NIMS receives a petition to list 5 more stocks, and this time it's stocks that are in the White Salmon River. NIMS comments on the EIS scoping document, recommends that dam removal be assessed under NEPA as a fish passage alternative. And the EIS scoping document 2 comes out. Very important, Washington Department of Ecology sets flow and ramping rates, basically what we asked for, 200 CFS in the winter and 150 CFS other times, and very modest ramping rates. The license expires in '93, and FERC authorizes a Pacific to operate 1 more year if no license is granted. American River files comments with FERC on scoping document 2, urges FERC to evaluate the erosion dam removal alternative. So we're starting to get serious about dam removal as a way to get fish passage. Pacific proposes all these genetic studies and raises all these questions and so on about harvest. And I don't know what that had to do with it, but they did. NIMS wrote a letter rejecting more studies. Nevertheless, Pacific hires Jim Likotowicz, who's a real high-powered consultant now, to study it, and so it's more petitions, and this time you got Middle Columbia steelhead are in there in the white salmon. More petitions under the ESA, and then in '94, there was some question about that 401 certification, but it went all the way to the Supreme Court, not this one, but another one, that affirmed that the Clean Water Act allows states to impose conditions on federally licensed projects based on water quality standards, including in-stream flow requirements. I thought that was brilliant. And then each party files prescriptions and recommendations for the project, including gravel augmentation, ramping rates, in-stream flows, fish ladder, powerhouse, tail race barrier, fish screen and bypass system, spillway modifications. The spillway, fish came over the spillway were basically going to fall on rocks at the time, or dam removal as the most fail-safe method of fish passage. More maneuvering on the part of Pacific to get around this by recommending more studies and hiring more consultants. The Northwest Steelheaders fights us a bit over asking for more studies. Pacific Fishery Management Council passes a resolution in support of fish passage at Condit Dam and fish restoration. Another ESA petition or listing the coho salmon this time. The Columbia Basin Fish and Wildlife Authority submitted a plan for ecosystem restoration of the White Salmon River. I worked with the tribes and CritFic and the states and National Marine Fisheries, everybody on that. FERC produces a EIS with 4 alternatives, including dam removal and partial dam removal. Of course, no action. 1995, the Forest Service basically puts the resident anadromous question to bed by saying that the restoring anadromous fish could increase nutrient cycling and productivity of the system, benefiting the rainbow trout. The agencies and the tribe and the NGOs said that the EIS falls short by not adequately evaluating dam removal alternatives. They were basically said it's an alternative, but it's really expensive. And so American Rivers and the Yakima Indian Nation had Meyer Resources look at it, and they hired Dennis Cathard, a PE, review the removal options. Native Fish Society dumped all over the plans, saying it was become a hatchery dump for commercial fishing. FERC holds their 10J meeting to go over, resolve inconsistencies. That's what they do. If there's things that FERC staff and the agencies can't agree on, they hold a big meeting. Pacific contends that, this is kind of a last ditch here, Pacific contends that the White Salmon River is not navigable because splash dams were only temporary measures to flush logs downstream. In other words, all this relicensing was a waste of time because you do FERC, you don't have jurisdiction. So it's kind of a last ditch. But FERC rejected that basically. 96, the Pacific Yakama Indian Nation and CRIPFIC hire R.W. Beck to evaluate dam removal. FERC's EIS pays absolutely no attention to any of the stuff that Meyer and Gathard did. Meyer was an economic study, and they selected fish passage. Alternative 2 is the best alternative. At this time, FERC had never, there was one on the East Coast, Edwards Dam, but this was, and I think that was kind of different. This was all new to FERC, taking out a dam, decommissioning. The in-lieu site became a big topic of discussion. And the Yakima has wanted the dam out more as the in-lieu thing was kind of a side issue at the time, but it sure it held things up a bit. And this has already been gone over, but when Bonneville Dam was put in, it flooded a lot of fishing sites that the tribes had on the lower Columbia, including the mouth of the White Salmon. 35 fishing sites and Native American graves. Anyhow, we're past the relicensing and EIS, and now you're into the settlement talks. This is between all the parties got together in '97 and started talking about getting real about this and dam removal. The R.W. Beck dam removal initial assessment report came out. Pacific meets with interested parties to discuss the future of Condit Dam. Forms a technical work group. Technical work group discusses removal timing and some constraints. Pacific gets an extension on their license. And also discuss the irrigation takeouts and 52 cabin leaseholders, and that's kind of how it looked right after dam removal, where these guys had got used to living on a lake, but these were leaseholders. They didn't really own any of that land around Northwestern Lake. They leased the land from Pacific Corp. Anyhow, a lot of discussion about how to accomplish the dam removal. In 1997, Pacific announces an agreement in principle. And how to get there, doing the necessary permits and so on. And that continued on. We're talking 4.97 million for the blasting the existing tunnel plug with a gate to control drawdown. That was the first proposal. 98, the Fish and Wildlife determines that anadromous fish are always present, but timing will minimize impacts. And what they did was they went out and trapped the Tule Falls Chinook in the lower river, and basically just trucked them above the lake. Pacific files a second revised motion to hold proceedings in abeyance for parties to reach a settlement agreement. 1998, Pacific informs FERC that a settlement package will be ready by November. December 98, the interveners asked Pacific whether it's proposing a cap on total cost and years of operations required to justify construction and mitigation costs. And in 99, the interveners proposed a settlement agreement. So there's a lot of back and forth here. And then Pacific responds that it should not have a long-term responsibility towards the in-lieu site. And there's a cap on project removal and $1 million for the Yakima Fishery Enhancement Fund and $2 million for permitting and mitigation. No land or water rights were involved. And there's a 7-year removal schedule, removal commencing in 2006. Well, that slipped a lot because of Corps of Engineers and Washington Department of Ecology permitting. FERC gives Pacific until June 99 to reach a settlement. Meanwhile, more listings, I won't go over that. FERC asks NIMS for an update on ESA listings. Pacific informs FERC that settlement package will be ready by fall. And then basically the settlement was this: $13.65 million for removal, $2 million for permitting and mitigation, $1 million for Yakima Indian Nation Fishery Enhancement Fund, $500,000 for enhancement of in-lieu fishing at the mouth of the White Salmon River. And I'll get into my summary here. Basically, times really changed between 1913 when Condit Dam was completed and 68 and 99. The parties have to pay attention to the FERC relicensing process. You miss steps, you're out of it. You got to keep it's relentless. And you don't miss deadlines or else. And also pay attention to the 401 certificate comment period too, because that's real important in setting in-stream flows. Coordinate closely with your conservation partners and keep the attorneys at your side. Meet and form a joint fishery party and include the feds, the states, the tribe, and any relevant NGOs that are friendly. Beware of side processes that can derail the outcome, such as that wild and scenic river plan that said just resident fish. That was kind of scary. I had to fight with them a lot over that. And they had people, individuals in the Forest Service actually fighting us, outside of their agency, setting up websites and all kinds of stuff. It was pretty crazy. Seek endorsements. We got endorsements from the Pacific Fishery Management Council, the Northwest Power Playing Council, the Columbia River Fish Management Plan Production Advisory Committee, the managers. seek allies, the tribes, the fishery managers, sportsmen's groups, whitewater community, and use good science. This resonant versus anatomous was, that was kind of a, that was a lot of hearsay that they were using to fight us on restoration of anatomous fish production. Beware of proposals to study it forever, because studies are relatively cheap. We had the state proposing more studies, we had Pacific proposing more studies, everybody was proposing more studies, and we wanted to get it done. Learn from similar processes. We learned a lot from the LY experience. We learned a lot from watching Edwards Dam on the Kennebec go out back east, and so on. This dam removal is a kind of a new thing, and it's getting cheaper each time it's done because there's less things that need studying, or it's each one's unique, but there's a lot of common issues. And if you can fund a study, the tribe and American Rivers funded studies on economics of the project and basically shot it down. Said that really helped, I thought, to show how the recreation and fisheries were really worth quite a bit compared to the power. And this was at a time when power was dirt cheap in the Northwest. There was a real glut. You have to defend the settlement agreement after it's attacked. You had the counties trying to, we were fighting them. You had groups fighting. Everybody was trying to stop it. The cost of Pacific to upgrade the dam for effective fish passage turned out to be estimated to cost about $100 million. The cost to remove the dam ended up being about $35 million. And anyhow, that's about it.
Okay. Just a second. Try it.
Oh, sure.
Hi, I'm John Sample, and I'm with Pacificor. And I'd like to thank Jill and all the organizers for inviting me here today to speak. You've seen some excellent presentations by all the previous speakers, and a lot of it dealing with Condit. So I'm going to skip through a lot of the things that are repetitive and you've already learned. Of course, they say if you want to have somebody remember something, tell them 3 times. So you'll all get to remember a lot of this. And a little bit feels like this is your life, because a lot of the examples that we're using are Pacificor projects. Condit, Klamath, there was reference to the Bear River, and we aren't building that project that Megan talked about, but she mentioned that they had gone through a relicensing. There were environmental measures being implemented, and that's a Pacificor project that we worked with American Rivers on that. And we're working, coordinating, at least with American Rivers and other entities, on that Bear River Narrows project. So it's interesting to see a lot of the work I do every day up on the screen. So I'll start out, and I'll go through some of this pretty quickly. So you've seen all this before. Condit was finished construction in 1913. We say it's about 14 megawatts. Today, depending on how you measure that, would power about 7,000 homes. And when it was first built, it was built for a paper mill and to serve customers in Portland. We've talked about the FERC license expiring. One of the things just to note is, I think Jeanette and others talked about, there was about 2.42 million cubic yards of sediment that had accumulated above the dam. Now this is, everybody's touched on this, but this will give you a sense of how the company views the relicensing and when it goes to decommissioning. We've all talked about fish passage, and that was definitely central to PacifiCorp's decision to decommission the dam. Obviously, when we went into the process, into the FERC relicensing process, we were seeking to relicense the dam and continue generating. But the federal agencies, U.S. Fish and Wildlife and NIMS, have Section 18 fish prescription authority under the Federal Power Act. We've talked about that this morning. And they both required fish passage for the project under any new license scenario. So PacifiCorp determined that the cost of fish passage under any new license, no matter what length, was going to be uneconomic for the project. And Clayton talked about, and I think somebody else did too this morning, that we explored looking at dam decommissioning and dredging that sediment out so there would be less impact to the river once the dam was removed. And that ended up being more uneconomic than fish passage. So in the middle of the 90s, I think it was 1997, PacifiCorp formally started to engage with the settlement parties to talk about decommissioning. We did file a petition with FERC to stay the proceeding, and these are some of the stuff I'll spend a little more time on because FERC doesn't really know how to deal very well with dam decommissioning from a process standpoint. But we entered into the settlement talks and formal talks in 97, reached an agreement in 99 that would allow us to breach the dam and flush the sediment downstream. At the time, it was estimated that that would be less costly than it would be to either provide fish passage or to decommission the dam with dredging. Everyone recognized that there would be significant short-term impacts to the river, but I think we all believe that in the long run, there would be more benefits to the river than harm. And so dam removal from PacifiCorp's perspective was clearly motivated by economics. In operating a project, whether it's operating and generating electricity or decommissioning, anything we do has to be in our customers' best interest. And we felt that at this time, given the costs of fish passage, the dam decommissioning with a sediment flush downstream was going to be in our customers' best interest. One of the key things about it, and Clayton mentioned it, is there were, in the settlement, there was a cost cap. And that cost cap identified certain activities, allocated dollars to that, and came up with a total amount that said, this is what PacifiCorp, this is a cost cap for decommissioning. If we went over that, the company had the ability to step back out of the agreement. And in the original settlement agreement in 1999, that overall cost cap was $17.15 million. The agreement was amended in 2005 and that cost cap was increased to $20.45 million, still in 1999 dollars. As was mentioned, there were delays in the decommissioning, and about in 2009, I think, as those dollars get inflated up, that was part of the settlement agreement, the dollars would be inflated. The 2009 value of that cost cap was $28.5 million, and as mentioned, the decommissioning was estimated to be a little bit over $30 million at that time. So in terms of FERC implementation issues, as I said, FERC knows how to go through relicensing. You know, they've been doing it for years, but this idea of decommissioning was fairly new to them. And prior to entering into the decommissioning settlement agreement, Pacificor had this active relicensing proceeding before FERC. So at the time we entered into the settlement discussions, we did petition FERC to stay the proceeding. It was kind of interesting because FERC never actually answered that petition. They never issued an order. They just kind of put things on hold. They issued a couple orders subsequently and signaled that they were unwilling to hold the relicensing application in reserve for too long, and that they were unwilling to prejudge how long they would or would keep it on hold. That did create a lot of uncertainty for Pacificor and I think for the other settlement parties, because you don't know what FERC's going to do. You've got this licensing process before them. You're trying to negotiate a settlement to decommission, and the regulator really is not being clear about how they're going to handle the process. FERC also held that once a licensee goes down this surrender or decommissioning path, you can't turn around and go back to relicensing. So once you head down that path, you're going down that path. You can't resurrect your pending application, or you can't turn around and apply for a new license application. Kind of jumping ahead, in the end, actually, FERC did not dismiss the relicensing proceeding until it issued its surrender order in 2010. So it just kind of let it sit there. They never officially stayed the proceeding. They just let it sit until they issued the surrender order. So in 1999, when all the parties entered into the formal settlement agreement, Pacificor filed that settlement agreement with FERC and asked FERC to do a few things. One was to amend the existing license that had expired in 1993. As noted earlier, we were operating on annual licenses, and that's part of the Federal Power Act. If you're undergoing a relicensing proceeding and you go past the expiration date for your license, you automatically, I'll say, go on annual licenses, and those you operate under the same terms that you do of your original license, unless there's I'll say extraordinary conditions where FERC may be able to require some changes. So we've been operating on annual licenses for a number of years. We filed the settlement agreement in 1999, asked FERC to extend the original license from 1993 going forward. They refused to do that. We asked them to amend that license and incorporate the settlement agreement provisions, and they said, no, we actually consider your filing, your request for an amendment of the existing license as a petition to surrender the project. And they held also that the surrender activities, and this is their 2010 order, that the surrender activities, they have control over you and over the surrender order activities until you complete all of them to FERC's satisfaction. And so that way the commission really keeps the licensee under regulatory authority until everything's done. I think the Federal Power Act talks in terms of generating electricity, and some have argued that if you stop generation, FERC ceases jurisdiction over you, but clearly their position is you are under FERC jurisdiction until you complete all the activities under a surrender order. FERC also rejected the idea of a cost cap, and that really wasn't a surprise to most folks who follow FERC. They typically don't allow cost caps in their, don't put them in their orders. They focus on requiring certain activities and requiring you to complete those no matter what the cost. One of the things that became an issue in the decommissioning and trying to carry it out was federal preemption. And as has been talked about, the local counties, Skamania and Klickitat County, opposed the decommissioning. And that created a lot of uncertainty for PacifiCorp because we didn't know what we were going to face in decommissioning requirements. We saw the surrender order, but you don't know what you're going to deal with the counties. And so FERC, PacifiCorp in 2005 petitioned FERC and asked them for a declaratory order saying that state and local authorities were preempted as to FERC decommissioning. In 2006, FERC issued that order, and they held that state and local authority was preempted and it couldn't be used to hinder or interfere with a FERC sanctioned decommissioning. It was interesting though, FERC held that what they could do, and this is what FERC could do, was to require the licensee, in this case PacifiCorp, to work with the local authorities or state authorities that were preempted to find out what they would require. And then it was in FERC's sole discretion to say whether you had to do that or not. So even while their regulatory authority would be preempted, FERC wanted PacifiCorp in this case to work with the local entities, in this case the counties, find out what they wanted, and then FERC in its sole discretion would decide whether PacifiCorp would have to undertake that. FERC actually said in its order that it wanted its licensees to be good citizens of the community, and therefore, if they could comply with county regulations, they'd require the licensee to do that. So there were a lot of delays in the decommissioning. As pointed out, I think I even lose track of what all the original dates were, but I think in the 1999 settlement agreement, there was project schedule, and the original schedule was to have the project cease generation in 2006 with decommissioning to start in 2007. As been talked about, permitting was a big issue. It took a lot longer to acquire permits. It was a lot more costly. The original estimate or line item that contributed to the cost cap in '99 was $2 million for permitting costs. In 2005, that was revised to $5.3 million. So just permitting was a big issue. And it was, the delays were caused in part by the novelty of the process. Again, we've heard this. This was the biggest one at the time. There weren't a lot of other examples to draw from. And just this idea of flushing sediment down the stream was, if it's not a relatively new concept, it certainly wasn't tested very, very often. And you had the opposition of the counties. The counties wanted to see the dam stay, they wanted the lake to stay, and they were spending a lot of time and energy to try to oppose the decommissioning. Also, the water quality regulations that would allow ecology to issue a 401 certification aren't very well suited for certifying this type of activity. With a decommissioning, you're going to have substantial impacts to water quality in the short term, and water quality regs are really designed not to allow that type of activity. The parties did agree to extend the decommissioning date until 2010, so permits could be finalized, and in doing that, it allowed the project to generate longer to create more funds to pay for the additional costs. Ultimately, PacifiCorp believed that the 401 was really the critical path to getting the project decommissioned. It was really unclear for Ecology how they were going to do this. Again, they were trying to authorize this massive release of sediment downstream that would have turbidity and sedimentation issues. The agency looked at various ways of doing it and was really not sure how to certify it. As mentioned before, FERC couldn't issue a surrender order without a 401 water quality certification. 401 of the Clean Water Act requires that a certification prior to the issuance of any federal license or permit for any activity authorizing a discharge into a navigable waterway. And we touched recently briefly on navigability, and there are a lot of different definitions depending on what forum you're in. So FERC couldn't issue its surrender order until Ecology either certified the project under 401 or waived. And likewise, the Corps of Engineers had to issue a 404 permit. So that's a fill and removal permit, and they could not do that unless a water quality certification was issued. So ultimately, though, Ecology did issue their 401 cert in October 2010. FERC followed on shortly after that in December 2010 with its surrender order, and the Corps issued its 404 permit in May 2011. So yeah, more about the 401 cert. Washington Department of Ecology was very cautious about this. As clear, it was expected to exceed a lot of water quality criteria, particularly turbidity. And those exceedances would be, what do I want to say, very, very profound for the short term. But then there was also expected to be water quality exceedances over a period of time, typically during high runoff events in the spring and things like that when there's high water flows. So it really was a challenge to certify this project because it wasn't over a short period of time. They expected over many years they may see exceedances from sediment still becoming mobilized and running down the river. Again, the water quality standards weren't really designed for this type of activity, something like a dam removal or even in-water stream restoration projects. What Ecology looked at were some various avenues, and that is variance under the Clean Water Act, use of a mixing zone downstream of the project, a short-term modification, a compliance schedule, or as I mentioned, waiver of the project. That was something that was considered, but I think taken off the table fairly early. This kind of regulatory impasse where everybody was waiting for the 401 cert to come out was overcome eventually because PacifiCorp started negotiating with the counties concerning their oppositions, eventually entered into a settlement agreement with the counties, and a couple of the things that did was require them not to oppose the decommissioning and not to challenge the 401 cert. So given that, Ecology ultimately authorized the water quality exceedances associated with the decommissioning through a 10-year compliance schedule. And what that functionally does and how EPA interprets that is it allows Ecology to use their enforcement discretion to say they can certify that this activity will meet water quality standards over a period of time, recognizing that during the compliance schedule, the project may exceed water quality standards, which it did and can still do, but after the 10 years, that activity has to come into compliance with standards. We found, from trying to carry this process out, that it was a little ironic that water quality protection became kind of the major obstacle for us in carrying out a dam decommissioning. One thing just to notice is that in recognition of these kind of problems and obstacles to decommissioning, just in September of this year, EPA is proposing revisions to its water quality standards regulations. And so each state, when they adopt a water quality standard, have to submit it to EPA to get approved by EPA. And so EPA is revising its standards and have proposed a variance for, I quote, actions necessary to facilitate restoration through dam removal. So there is new proposed regulations by EPA that would actually recognize the benefits of dam removal and allow for water quality variances to allow this type of activity to occur, knowing that it would, particularly for turbidity, that would clearly exceed numeric standards. Sediment management, I'll go through this a little more quickly because I think it's been covered elsewhere. Condit was kind of in the vanguard of doing this. There weren't a lot of other examples. And it was unclear how effectively that sediment would move out. As I said, there was about 2.4 million cubic yards of sediment above the dam. As a result, and I think Clayton, you referred to, there was a lot of people doing studies, and Pacificor, Department of Ecology, FERC, and others studied sediment transport, turbidity issues, what happens if that tunnel, you've seen the blast that came through, blast out the last part of the dam and created the tunnel that all the sediment went through. What happens if that got blocked? There was contingencies for if the sediment didn't mobilize and a lot of it stayed on the banks, how would they get that down? Some of that at least was planned for through the use of water cannons. And I think there was a slide earlier that showed mechanically just knocking it down into the river. They looked at effects to the Columbia River. There was a delta that was created out at the mouth of the White Salmon. So a lot of sediment did go out into the Columbia. It didn't interfere. Well, now some of the shipping traffic has to just change course to wrap around that delta, and there's one just upstream at the mouth of the Hood River. But it didn't have significant impacts on the shipping channel or on the Bonneville Pool. The sediment did evacuate very much as expected, but as mentioned a number of times, originally we thought it was going to take about 6 hours to drain the lake, and it took less than 2. And I had the good fortune of being able to go out on the dam within about 20 minutes. I was one of the first groups out on the dam and stayed out there the whole time and watched the reservoir drain, and it was a pretty darn amazing event. A large percentage of the sediment did mobilize, and about 1.7 million cubic yards with the initial draining of the reservoir, and then within the first year. Ancillary impacts, I'll get through that pretty quickly. There was some talk about the Underwood and Luce site. There was clearly sedimentation down at the mouth. The city of White Salmon had a water line that had been laid across the bottom of the reservoir to supply water to city residents. We entered in, as part of our agreement with the counties, we rebuilt that water line, went across a bridge over the river rather than going along the base of the reservoir. Upstream of the project, there was a natural gas pipeline. There was concerns about erosion. There were some erosion issues, nothing that created a safety issue for it, but Northwest, it was, what's it called? Northwest Pipeline actually removed it out of the river after the decommissioning and routed it over the river. The Klickitat County had a bridge that went across the river prior to decommissioning. We undertook to put new supports on the bridge due to concerns about scouring, and actually with the decommissioning there was a fair amount of scouring. We had to go back in and do some more work on that. And then well owners, we haven't talked about that a lot, but in dropping the reservoir, you drop the water table, the water table dropped. water elevation prior to dam breach compared to what it was down near the base of the dam was about a 100-foot drop. And so that has affected the water table. There's a lot of groundwater wells there. There's been some pictures of these cabins that are sitting along the lake. Those typically all that Pacific Core land, and those are leased cabin sites, and people build their cabins there. And we've been working with impacted well owners to mitigate the impacts, and that's usually either to deepen their wells or to drill new wells. And that's something I think Dean Amos talked about it. That's governed by state law, and FERC didn't require Pacific Core to do that, but we just felt it was in the company's best interest to work with some lessees or landowners there to mitigate well issues. Let me see. I've got through most of that stuff. I think it was mentioned earlier, there was a whole bunch of management plans. I think we had about 15 management plans that we had to put together, submit to FERC for approval before we could start decommissioning. Those dealt like things like public safety, cultural resources, erosion control, dust control, environmental monitoring, revegetation of wetlands, aquatic resource protection, and recreational facilities. Once we submitted them to FERC, FERC approved them fairly quickly, and we were able to implement them. As I said, some of the only unexpected stuff was with the additional erosion to the dam and then the gas pipeline. I think you've seen a lot of this already, kind of what the schedule was. The dam breach was in October. Along with the dam breach, we undertook things like removing the flow line. That's the project feature that would take the water from the dam down to the powerhouse, and started removing the superstructure on the dam. Later in February through September of 2012 was the actual deconstruction of the dam, breaking up the concrete, taking it out of the river. A lot of slope stabilization work. One of the things, again, it seems a little counterintuitive, is Department of Ecology wanted us to actually knock as much of the sediment into the river as possible, which you just think, why would they want you to do that? You know, it's like muddy up the river. But they wanted it all done in a short period of time. Get those impacts over so that you don't have long-term sedimentation and turbidity issues. And then in late 2012 into 2013, we did start hydroseeding that whole reservoir area and planted over 14,000 trees for slope stability. And what's going on right now is continued slope stabilization, water quality monitoring, and revegetation. So you've seen pictures, and there's just another one of the dam site after removal. And one of the things is, you saw a couple of the video clips. If you go to that website, pacificcore.com/Condit, there'll be those full videos. There's a lot of information on dam decommissioning, relicensing, some on construction of the dam. You have to root around. There's a bunch of pages, but you'll find a whole area that have a lot of videos. Thank you.